I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are on number 260 on our compilation list. Before I give you the rundown of the judges, which will be 5 different courtrooms that we will be in on today, don't forget to like, comment, share, and subscribe. Also, commentary will be left in these proceedings where commentary was before, and chapters will be added, especially with the 5 different courtrooms for your convenience. Now, the 5 judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. Second, we will be in the unknown courtroom. I do know the sovereign citizen's name is Mr. Taylor, so that's where we will be for our second proceeding. Third, we will be in the courtroom of Magistrate Delphia Burton out of the state of Michigan. Fourth, we will be in the courtroom of Judge Victoria Shackelford, also out of the state of Michigan. And last but not least, also coming out of the state of Michigan, we will be in the courtroom of Magistrate Laura Echartea. As always, guys, it is a pleasure doing these compilations for you and having you guys sit in on these. And today we got a nice variety for you, so enjoy, and let's go ahead and jump into 260.
All right, Mr. Harris, this is the City of Detroit versus Christopher Gray. Case number SP 1357945, counts 1, 2, and 3. SP 1191985, counts 1 and counts 2. SP 1629749, counts 1 and counts 2. SP 1267865, counts 1, 2, and 3. And appearance for the record, please.
Sheriff Harris, on behalf of Mr. Gray, please state your name for the record.
Mr. Gray's appearing. I'm here as a special appearance. Mr. Gray's appearing at pro se.
Okay, Mr. Gray.
Okay, strike that appearance. Thank you.
State your name, Mr. Gray, for the record, please.
By special appearance, I'm here to appear for Christopher Lamar Gray.
All right. Today is the date and time set for a show cause. Mr. Gray, you missed the court date, sir.
I apologize. Your Honor. I made every attempt to get in. I didn't see my name on the docket when what I assumed was my date. So I don't know how I lost track of that. I do apologize, Your Honor. And
okay. All right. So let's do it. So your name is Christopher Gray. Is that correct?
My name.
That's what you just. Wait a minute. Let me just say what you just said. Let me just say what you just said. I didn't see my name on the docket.
I'm the trustee for the account. So for that.
I'm gonna call you Christopher Gray because that's what we're looking for. And then I'm gonna enter a not guilty plea on your behalf. I'm gonna give you a $0 bond.
Okay. Objection, Your Honor. I would like for the record, I reserve my right not to be compelled to perform on any contract, commercial agreement that I didn't enter knowingly, voluntarily, intentionally, and I furthermore do not accept any liability or compelled or otherwise for any contracts that I did not know that I became a part of because of a license or anything else, Your Honor. So I object, and for the record, the state can't be named a party in this suit. I asked that I put a motion before the court. I didn't get a ruling on that motion. I asked the court rule on my motion.
What is your motion? I haven't seen any motions. What is your motion?
I have a motion to dismiss, motion to strike.
And what is the basis for that?
The basis of that is there is no corpus delicti. The 3 components are there are not those 3 components. There's only one of the 3 components here. Okay, the occurrence of loss of injury, that's not here. The whatever happened legally to cause or illegally to cause that loss, that's not here either. So of the 3 things, the third thing would be me being named. That's here, but the other things aren't here.
Okay.
So
is that all?
yes, yes, Your Honor.
Okay. Your motion is denied, Mr. Gray. All right. Now I'm going to set this matter for a jury trial again. Let's see if we can get one quicker. Say that again.
You want to know if he ever had a jury trial?
Yeah, he had a jury trial since July the 5th, but now it's not been set anymore, right? Let's get a date, if we can get a date quicker than that. And for the record, I did not receive anything. Did you get the name? No, we don't check right now. I don't have anything in the file. We're gonna check the mail to see if did you mail that motion in, Mr. Gray?
That motion, one moment, Your Honor.
The motion is denied anyway, but I just want to make sure that we didn't miss anything here. Ms. Mathis, you can check the email to see if Mr. Gray filed any motion.
Okay.
Again, Your Honor, I object. Article 3, Section 2, Clause 2 says that because the state has been named, in cases that the state is named, then in those cases involving ambassadors, public ministers, councils, and those in which the state has been named, those fall under the original jurisdiction of the Supreme Court. So that is my objection, and I put that on the record that if the state is being named, which the city of Detroit would be the state, then this matter doesn't fall in your jurisdiction; it falls in the Supreme Court.
All right. Well, you can put that in a motion or whatever you want to do, but I don't interpret the law that way, and your objection is noted for the record.
Well, I object to you ruling on. I object to you putting in a defense on my behalf. I didn't request that. I didn't put
a defense on your behalf.
You put in a not guilty, and I didn't plead that. So that's.
So you want to plead? You have two options. You have two options. You want to plead guilty, not guilty, or you want to stand mute. 3 options. What do you want to do?
I stand mute.
All right, stand mute. And based on that standing mute, I'm going to enter a not guilty plea on your behalf. All right.
I object to the entering of a plea on my behalf, Your Honor.
Objection is noted on the record.
Thank you.
Well, I'm checking.
All right, let's pass the matter. I'm going to get another jury trial date, Mr. Gray, and we'll get you out of here. Next time you miss, sir, it's going to be a cash bond on you. I'll let you know that.
Understood. Appreciate your patience, Your Honor.
Let's do the fine 27.
You want to add another 2
We'll add 2, and we can add it to the afternoon docket, right? Hey, let's do it. Yeah. You know? Huh?
Because they want the people to be here at 9:30.
No.
Jury services.
We'll call. We'll put it on the afternoon.
But I don't know jury services.
We'll call them and find out. All right, let's pass the matter. We're gonna figure out this. We're gonna try to get this sooner rather than later, Mr. Gray. All right, you say the 27th. All right, let's go back on the record with Mr. Christopher Gray. Let's go back on the record for Mr. Christopher Gray. Mr. Gray, I'm going to give you a jury trial date of May the 27th, 2025 at 9 a.m. Okay?
Your Honor,
let's say 8:30.
Your Honor, I think I have in Third Circuit Court a pending case.
All right. Well, what do you have in Third Circuit?
Issue with land bank.
You don't have a choice. You come to in person at 8:30. You've already missed the day. You don't have a choice. You have to figure it out.
Okay.
In person, sir.
Will do.
All right. Have a great day.
Thank you, Your Honor.
All right. still waiting on, that appointed counsel, Mr. Lucy. We'll get you out of here as soon as they come.
Thank you, Your Honor.
Let's tell Mr. Gray, before you leave. Ms. Snyder,
Good morning, Your Honor.
how are you? I have Mr. Gray. He is appearing per se. We set a jury trial for the 27th of May. Let's do this. Let's go back on the record with Mr. Gray. Let's go back on the record with Mr. Gray. Ms. Snyder, can you put your appearance on the record, please?
Alexa Schneider for the people, P80322. Is this Christopher Gray?
Yes.
It is. No, this is Christopher appearing for the account of Christopher Gray.
He doesn't know. He's Christopher Gray at one moment, and he gets confused. Now he's Christopher Gray appearing on behalf.
I am the trustee for that account.
For that
trustee for that account.
All right. So anyway, Miss Snyder, can you get your officers here on the 27th? Let's say the 27th is right after the holiday. I know that's short notice for your it's a week and a half. I would like to get this done. Give Mr. Gray his day in court.
I have a few points, Your Honor. First is I will not be here on the 27th. So I would have to ask that we not set a jury trial on that date. I wouldn't be able to get anyone to cover. So I could not have a jury trial. I would object to setting it shorter than the 2 weeks without having the chance to talk to the officers. If they were here in person or on Zoom, I could ask them, but I just don't know their schedules. They might be on furlough. They might have medical issues. And third, I would object to Mr. Gray representing anyone, be that an account or another person. Since he is not an attorney, he cannot represent anyone.
All right. I'll rule on I'll hold your objection in obeyance, and I'll rule on them on another jury trial date. Ms. Mathis, please. June the 10th can't be. All right, June the 24th. June the 24th, 2025. That's going to be in person. We're going to set a final pretrial date for the day before that, for June the 23rd, 2025 at 8:30. That's all the parties need to appear. They do not need to appear in person. You can appear on Zoom, but we want to make sure that at least we have some officers that are going to testify and to give testimony for the people to make see if they can not to make the out see if they'll be available for the trial the next day, so we don't inconvenience the jury. So a jury trial is the 24th of June, 2025 at 9 a.m. And a final pretrial is going to be June 23rd, 2025 at 8:30. And that jury trial is going to be in person. And then all parties must appear for the June 23rd final pretrial date. Understood?
Is this for all of the charges on the docket, Your Honor?
Yes, this is for all the charges except for the civil infractions. We're not entertaining those at all.
Thank you, Your Honor.
And he had maybe some more. No, it's all. It's I think I counted 10, and I counted 10 into the record. All right. Anything further from either party? All right, hearing no response. Everybody
yes, Your Honor. Yes, understood.
All right. Good. Hearing no response. Have a very good day, and best of luck to you, Mr. Gray. And
thank you, Your Honor.
Captain Taylor. Very good.
We'll next call the case of the state versus Sebastian Taylor. It's case 26 CM 1649. Appearances, please.
Sam Smith for the state. Mr. Taylor appears in person in custody by attorney Luke Vagley.
But I don't need an attorney.
Okay. Well, you're not required to have him, but
Thank you.
he's
Do you want my help?
No, I don't.
No? Are you sure?
No.
okay. So let's
I'm a
talk.
secured party creditor.
So I don't speak sovereign, so
Not sovereign.
okay. Well, you're welcome to have Mr. Vagley help you here today or not. It's up to you.
I have a question. You're in the third lane, right here. There's 3 lanes. There's the bus lane, the red one. You know, everybody has that.
Mr. Taylor, this
And
is
you're
my
driving-
number, please.
Wait, he's slipped me.
So
Stop for a second.
my advice to you is
He's
do not
let
do
me
this.
talk. Okay? There's 3 lanes. 2, the bus lane. Kelly's Market's right there. I'm going to Kelly's Market. I gotta cross over that lane to get there. How do you not do that?
Well, I don't know. And I don't know what that has to do with the case just yet because I didn't get quite that far.
Okay.
But let's just make sure that Mr. Taylor has a copy of the complaint. Looks like he's holding that in his hand. Mr. Taylor, is the address on Luann Lane the best one to use for you for mail?
Yes.
Okay, great, thank you. So I should just find out, do we know whether he would qualify for a public defender if he wanted it?
I have no information on that.
Okay, so he's here and he'll help you today if you want that. If you want to represent yourself, that's your right. I have no problems with that.
Mr. Taylor, I'm happy to help you if you want to represent yourself.
I know that you guys just get people into more in time and I didn't do anything wrong here, so I feel that I can help myself.
Okay, well, I mean, I'm not gonna try to talk you into or out of anything, but a person who's innocent is probably a person who even more needs a lawyer to help represent their interests in a lot of ways. But we'll sort through that. If at some point you change your mind, he'll be here. And you always are free to hire a lawyer later on or get in touch with the public defender's office. Not a problem. State of a position regarding bail on this?
Signature bond and the standard conditions.
It's resisting.
Yes.
I feel that it should be thrown out.
Okay, and is that a motion to dismiss the complaint? And if so, what are the grounds?
I had to go to Kelly's Market, it's all standard from me crossing that bus thing or whatever. But how am I supposed to get there? If I don't go over it, it's right there. I'm in these lanes, but it's right there. I gotta go over that to get to Kelly's Market.
Okay,
And I felt that the officer was a little hot-headed. He was kind of nice at the end, but it didn't have to go on like that.
all right, and I suppose both parties have access to the complaint. The complaint suggests that he was originally pulled over for driving in a restricted lane and for speeding, so I get why that's sort
And he
of
didn't cite me for speeding either, so
great. Okay, but what's charged in the complaint is what's alleged to have happened after all that, but state of anything more it wants to add regarding bail?
Not regarding bail. If you need me to respond to if there's a formal probable cause challenge to the complaint, I'm happy to respond, but nothing more to add in regards to bail.
Okay, and Mr. Taylor, did you want to add anything regarding either bail or your request that the complaint be dismissed?
I just request us dismissed. I guess she was a little hot-headed, and I guess I was too, but how am I supposed to get over to Kelly's Market through that bus thing? Can somebody tell me that? I mean, there's 2 lanes, the bus. I'm going that way to Kelly's Market. Is there another way I'm supposed to do it? Honestly.
Well, so for today's purposes, I'm more concerned about what's alleged to have happened after you were stopped. And I don't want you to necessarily say anything about that because I don't want you to say something that could get used against you later
I
on.
know, but that wouldn't happen if I didn't cross over that. How can we not look at that either? I don't understand.
Okay. And is there anything about either your background or your ties to the community or anything like that that would support my allowing you to be released on a signature bond?
I'm a nice guy. I'm good with everybody. Everybody likes me.
Appreciate that.
Yeah.
Thank you for that.
And I'm not a bad guy.
All right. And I'm just taking a little bit closer look at the complaint.
And honestly, if that happened again, I don't know what to do with, unless you tell me what to do on that. But not supposed to turn to get to Kelly's Market over the bus thing? I mean, it's right there. That's why I say it should be thrown out. This is petty and a waste of the state's money and time.
Mr. Taylor. Okay, so, and the state's still supportive of a signature bond? Yep. The DSA does recommend a signature bond. It says he doesn't have any prior failures to appear in the last couple of years. So that's to his credit. Well, I'm going to order a signature bond. I go along with the joint request on that. Mr. Taylor, I think the state did you a solid on that. I'm not sure I would have set a signature bond in this case if the state hadn't asked for it. This is all of the stuff that happens during the stop is pretty concerning from a bail perspective and an appearance perspective. Whether you're right or wrong about the reasons he got stopped, that's not an issue that's in front of us here. If you got some kind of traffic ticket for that, you have the right to contest that, of course. In court is where you contest that stuff, not on the side of the road here. But I'll give it a shot. I hope it works. You know, you don't have a bad history of making court. You said you're a nice guy. I'll take you in, at your word on that. I'll order the signature bond. We're going to have a bond form for you to sign here next door. Okay? Do yourself a favor. If you want to be released, sign the bond form. Don't put rights reservations clauses on it or UCC codes or any of that kind of stuff. If you do, the jail's not going to release you. It doesn't make any sense. Don't do it. Just don't play that game. Good luck to you.
This way, sir. Very good one. Next is Josario Niederhauser, appearing via Zoom.
Chamberlain, just stand right in front of that one.
Oh, looks like HP is in the waiting room too. So we'll bring him in. All right, good morning, sir. Give me one moment.
Good morning.
Highland Park. Oh, is that Officer Monroe? Hello, Highland Park. Okay, we're gonna wait. Your name, sir, for the record.
I'm at your Roman Sister Trust Legal Fiction Corporate Entity Defendant. That's what you want to know. I am one of
the
sovereign people.
Yes. Okay, all right, so this is for Eric Joseph Martin. And officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay.
I object to that any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase RIC of the capital M lowercase ARTIN family, one of the living people living on the land. Not the corporate entity defendant.
Okay, sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people of the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P86378, appearing on behalf of Mr. Martin, Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the battle. Move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the U.S. Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a U.S. Supreme Court case. Defining probable cause is fact sufficient for the belief. There is no fact for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault.
Mr. Martin.
Hold on,
Mr. Martin.
It's kidnapping.
No. No. What we're gonna do, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing, and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm gonna, entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
It's arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just gonna set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because see, the officer filled out the complaint form. He's lying by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been arrested. I should be here now. The charge is dismissed. There is no evidence here.
Talk over me, Mr. Martin.
My sister has been caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed her. So she really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9074 Clifford in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2 a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Man, they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're going to have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process. I can't live there because she makes up a lying allegation. I do not lose that right. That's my right.
You have a pretrial that's scheduled for June the 23rd. You have a pretrial scheduled for June 23rd at 9 o'clock. There is a no contact provision, and you cannot return to the Clifford location. And if you do, sir, that'll be a violation of your bond, and you will end up back before a judge in Taylor to address that. So thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave the state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human right. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habit that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. You're going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done.
What is her name? Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer. Take care.
Thank you, Your Honor.
So we have Mr. Martin. Mr. Martin, sir, are you ready to be arraigned? Can you come up here, please?
This is Mr. Martin. All right, this is 251756, the people versus Eric Martin. Mr. Martin, can you tell me your first and last name?
No, really don't want to give no name, so it's not fraudulent presumed on something else.
All right, well, I recognize you. You're Eric Martin. Sir, you've been brought to court on some charges here. Count 1 and count 2. The warrant alleges on June 12th of 2025 at property located at 9074 Clifford in the city of Taylor, a foreign complaint in this court was filed against you stating that on that date and location, the defendant, that's you, contrary to law, 1, did make an assault or an assault and battery upon the following person, Lisa K. Martin, contrary to MCL 750.81, parent 1. That's a misdemeanor punishable by up to 93 days in jail and up to $500 fine. He's already been arraigned. Yeah, he's just. Oh, so you know the original charges against you. And part of those charges against you, let's see. You could not have any contact with the complaining witness, Lisa K. Martin. You could not go to the address at 9074 Clifford. And you could not have any contact through the phone. You couldn't go in person. You couldn't go to the residence, period. And there's an allegation. I've got a report. You were arraigned on these allegations. It looks like on the 14th out county by Judge Burton. And then I have a police report that alleges on June 16th, officers were dispatched to that location. And there are allegations that you entered the residence through the back door and were actually in the home at time of arrest for violating your bond conditions. Those are the allegations against you.
So I move to dismiss the charges because the alleged bond conditions supposedly against me, which is really not against me anyways. Legal fiction, corporate entity defendant, which is not me. I'm a living man. But anyways, besides that issue, the bond conditions violate my right to be presumed innocent before guilty. Because I am presumed innocent before guilty, any bond conditions violate my right. Because if I'm innocent, then I cannot be told you can't do this, you can't do that.
So, Mr. Martin, are you entering a guilty or not guilty plea on that violation?
First of all, I'm not a defendant, so I'm not here to enter a plea. How can I enter a plea? I'm not the one charged.
Okay, then I'm going to say you're standing mute. It's my understanding you've refused to meet with counsel. You don't want an attorney. So I'm entering a not guilty plea on your behalf.
Oh, okay. Well, so have you made the legal determination that I'm not guilty?
No, sir. I'm doing it based on your arraignment. You understand the allegation against you. Do you? I just told you what it is. The allegation is you violated a condition of your bond on an assault and battery domestic violence case by returning to the address after being ordered you could not return to the address.
Well, like I said, I moved to like I said, bond conditions violate the right to be presumed innocent anyway, so that's no true bond condition violation is legit anyways. And there's no probable
Okay.
cause for this case. I should have been arrested illegally anyways, because there is no evidence. My sister lied, her allegations are a total lie.
All right, you have a right to remain silent.
Why are you
Anything
cutting
you
me
say
off on that
orally
now?
or in writing can and will be used against you, sir. You understand what the allegation is? You were
You're
just
not-
arraigned on it 2 days before picking up this, the original charge 2 days before picking up this violation. Mr.
No, I
Martin,
did not
this is,
understand.
I hear you. This is standard for you. And I honestly, you won't listen to court orders. You think they don't apply to you. You continue to go back to a residence you've been advised not to go to. You have a $25,000 cash or surety bond with a GPS tether.
Well, first of all, I don't have a choice. I have another house to go to for one. Besides, it's
Okay.
violating my
Well,
rights.
now you do. Now you do, Mr. Morton. You've got another house to go to now. It's
Yeah, well,
called Wayne
guess what?
County Jail.
You
We'll
guys
see you
are
at your
violating
next
my
court date. All right,
There-
thank you,
I'm-
officer. We'll see you next time, Mr. Martin.
Okay, goodbye. Mr. Martin? Okay, goodbye. Have a seat, Eric.
Well, guys, we have come to the end of both of these proceedings. I'm not going to do any commentary on that first one because I already did it yesterday, and it's not even a whole lot to say about either one. We see Eric Martin up to his old tricks again, same sovereign citizen lingo, gets into it with his sister. For whatever reason, he does not follow the bond conditions, and here we are. He was told specifically by Magistrate Burton what to do and what not to do, and he totally disobeyed that. And just like Judge Shackelford said, why? Because he doesn't really believe that it applies to him anyway. And also, he says it's because he has no place to go, which we see Judge Shackelford responds, "You do now," and that is in prison. Will he make bond again? Who knows? Will he make bond and go back to the house? Who knows? But like I said, I haven't covered this guy as many times as he's been in court. I've had the opportunity to. I've had some of the videos, but I just didn't really feel led to share all of those proceedings. This is probably my third and fourth one with Eric Martin, but I mean, clearly it's, obviously it's something going on with this guy, but for him to constantly be back and forth in court and jail like this, spewing the same stuff, it's kind of amazing. But I will follow up in this particular case since, I started out, with that last proceeding in this one. I will follow it through, God willing, Lord willing. But with that being said, guys, comment down in the comment section, give your thoughts. I don't really have a whole lot to say on it. But hopefully he if he gets out, he does the right thing and just stays away from the house. But he already told Judge Shackelford, I have nowhere else to go. So more than likely, he'll be right back there at the house and probably more than likely back before another judge, maybe even before his next court date. But with that being said, guys, this is Sovereign Citizens Hall of Fame. I always appreciate you guys for joining me. Don't forget to like, share, subscribe, all of those good things. And without, if there's nothing else, which I don't think there is, this is Sovereign Citizens Court, guys. And for now, Sovereign Citizens Court is adjourned. Thank you, guys. Talk to you guys soon, and God bless.
What's your name, sir?
The principal name is Joseph Montez Logan. I'm an agent on behalf of the principal.
I'm sorry, say it one more time.
I got a doable power of attorney filed in Wayne County Register of Deeds. The principal name is Joseph Montez Logan. I'm an agent on behalf of the principal.
Okay, you're Joseph Montez Logan
Yes,
or Logan?
Yeah, that's my principal. Yes, ma'am.
That's your name. Sir, I'm Magistrate Echartea. You're here on a criminal matter. 250-453-2601. You have an attorney. Go ahead, counsel. Counsel Reagan, you wait for a reading. Stand mute.
Judge, he's representing himself. He's the principal or the agent of the principal attorney of himself. He's representing himself.
Okay. So, Mr. Logan, you want to waive the formal reading, or do you want me to read the charges?
I would like to see the discovery first and the nature of the cause.
Okay, the discovery, that comes after, sir. Okay, this is only an arraignment. So my question is do you want me to read the charges to you or not?
Yes, ma'am. I'd like to hear the reading.
Okay, so, sir, people of the state of Michigan versus Joseph Montez Logan, allegedly on May 15, 2025, in the area of 18637 Albion Street, City of Detroit, did commit count 1 domestic violence, did make an assault or assault and battery upon a Tanisha Logan, a resident or former resident of his or her household, and or an individual with whom he has a child in common, and or his spouse, contrary to the MCL 750.812. Okay, maximum penalty is up to 93 days jail and or $500 fine. Do you understand that, sir?
No, ma'am. I do not understand that.
You do not?
At the moment,
what is it that you do not understand?
Well, because MCL 12.280 is gives you the personal liability of my agent capacity, and that gives you understanding of 1 and 2, saying that I have the same rights as a self-appointed a state appointee, the same rights as a state appointee, and I have no interest in this matter.
Okay, well, sir, you are the individual. I'm going to enter a plea of not guilty. It alleges that you did make an assault and battery on a Tanisha Logan. Okay. Again, the penalty is up to 93 days jail and or $500 fine. I'm going to enter a plea of not guilty. Let me give you your court date, sir, which is going to be May 28, 2025, free trial. It's an in-person hearing, let me make sure, 8:30, in person here at 36th District Court in front of Judge Austin Garrett. Do you understand that, sir?
No, ma'am.
No, I don't think that. I think you do understand, sir, because by your talking, okay, you do understand English. Whether or not you disagree with it, sir, that's another matter, Mr. Logan. But everything is placed on the record because everything is being recorded, sir. But I do believe you understand English. I'm giving you that court date. I'm also letting you know, sir, in terms of whether or not you wish to go forward, however it is, that's going to go in front of Judge Austin Garrett. Do you understand that?
No, ma'am. I do not understand any of the matter, any of the charges, none of what you're saying, because I'm actually the agent on behalf of the principal.
Okay.
No
well,
in this case, and you try to build a case on me personally, and I'm not liable. I don't have an interest in this matter.
Okay. Thank you, Mr. Logan, but you place that on the record. I've heard that. Sir, you still have that court date. I gave it to you. Okay. If you do not show up, a warrant will go out for your arrest. As to whether or not, like I said, when you want to argue as to motions or not, that's going to be between you and Judge Garrett. Okay. Let me give you some bond conditions, sir. That means you need to abide. You're not to have contact with a Tanisha Logan. That means no person-to-person contact. No contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. And you're not to go back to the no, that's your residence. So I'm not putting that on. Just no contact and no firearms. You understand that?
That was with the minor children involved.
The minor children, that, let me see. As to the minor children, sir, okay, that's up to family court. So I'm not dealing with the minor children.
So there's no stipulations?
Those two conditions, okay. I don't see anything to indicate that these children are subject of this case. So do you understand what I've just said, everything so far?
Ma'am, I do not understand, but I will take your ruling on behalf of the principal. I can only do what I can.
Okay, no problem. Okay, this allegedly happened at your residence, sir. I also see in this particular matter, there was no injuries. The complaint declined medical attention. Let me see what else.
I got a question, ma'am. Is she moving forward with the case?
Hold on. Okay. There was a 2016 domestic violence misdemeanor. I don't have anything else. What's your question, sir?
Is Tanisha Logan moving forward with the case?
Is she a what?
She's pressing charges, Tanisha Logan.
Okay. So you understand, Mr. Logan, okay? It is not up to the complainant to press charges. Charges come from the county, the prosecutor's office.
Oh, okay. Well, I'm just of the understanding that the state of Michigan is a legal fiction. It's not a living person.
Okay, it's the state of Michigan. That's why I read the state of Michigan, or the people of the state of Michigan versus you, sir. So
Okay.
it is up to the prosecutor's office that files the charges. They have filed the charges. Whatever happens after that, that's going to occur in front of Judge Austin Garrett, his courtroom. So I see that you have local ties. Anything else you want to add, sir?
No, not at the moment. No,
Okay, well, this is gonna be it, sir. In this case, bond is gonna be $25,000 personal bond. Nobody has to pay any money for you to get out of jail. I will caution you, sir, that you have no contact with the complainant. Even if the complainant wants to talk to you, you cannot, because you're under court order. Now, you can take all those issues up with Judge Austin Garrett on your court date of May 28th. Do you understand that, sir?
I was of the understanding that this was a misdemeanor charge and not a criminal charge. So I don't understand how.
No, it is a criminal charge. Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
Yes, that's crazy. Okay, well, I'll just fight it in court.
So $25,000 personal bond. Good luck, sir. You can step aside.
Well, guys, we have come to the end of the proceeding for Mr. Joseph Logan. As we can see, he is facing a serious charge, and it seems like he's had this charge in the past, according to Magistrate Echartea. He kept saying he doesn't understand, as if that was going to make the case go away. But then on the other hand, he confirms that the incident took place. One thing you notice in mostly all states is that anytime a domestic violence charge or an accusation goes forth, somebody's arrested for it, a lot of times it's no longer up to the victim to press charges, because the state takes it over for many different reasons. We've had people where they've gotten in domestic violence situations, recanted, said, listen, I don't want them to get in trouble, and unfortunately have lost their lives, so on and so forth. So most states, they don't play that. They take control of the case. They get involved. It's no longer up to the victim. Now you got to fight it in court against us and prove whether the victim is lying or not lying, if it happened or didn't happen. And that's what we've seen in this case. We see Magistrate Echartea be very adamant with Mr. Logan about staying away from the victim. Will he do that? Who knows? But many men and women have gotten in a lot of trouble by, crossing those boundaries, those what do you call it? The protective orders and stuff like that, like just not respecting them. And nowadays they take those things very serious. So hopefully he does the right thing. Hopefully, if he did put his hands on this young lady, he doesn't do it again. But May 28th, we will follow up with this case and see what happens. And with that being said, guys, thank you always for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, subscribe, and share. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. Catch you on the next one. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.